Folks, we're going to get started. If you want CLE credit, which considering this is labeled the CLE part of this training, we're going to show a CLE code, give you time to write down the code, and you should receive a final email that includes a copy of the agenda and additional materials, or you should have got it yesterday evening. If you didn't receive the email, get in touch with lawcle@fordham.edu. That's lawcle, one word, or together, @fordham.edu. To receive CLE credit, the affidavit and evaluation forms must be filled out within 30 days of the event. The forms will automatically mailed to the Fordham CLE team upon completion. So welcome to this training. This is how you get access to the CLE materials. So please use your phones to access this. Mic should work. What? Oh, it might. Yes, but I need to be able to. Oh, yes, I know it works. CLE, please do the CLE. If you need a code, it's on the next slide. But for those of you who have done it already, it is CHR25. Well, that's not the next slide. It's the code for this panel is CHR25. It's 2 slides. All right. Have folks mainly used their cameras to get the CLE code? The CLE. All right. There are 3 panelists. I'm Ellen Davidson from the Legal Aid Society, and I am joined by my colleagues Ed Josephson and Joanna Lane, also from the Legal Aid Society. And there's the code. All right. And now comes our training. If you wanted to do a quick intro. Yeah. There's also a mic you can use over there.
Everybody, good to see everybody in one room for change. And we're happy to be presenting this training on rent overcharges. which, is the, sort of the most exciting area of housing law, I think, because it's the one where you can actually make your plans rent go down instead of up, and make rent arrears go away and save people's apartments. So all good things. And what's so interesting about this training is that we do it a lot internally at Legal Aid. We have new attorney training, we have supervisor training, we have a middle attorneys training, and so potentially you get very bored on doing this training every few months, but it never does because the law keeps changing every like few months, if not weeks, and so we have to redo this slideshow over and over again. So this is the 5 minutes ago slideshow on rent overcharge for this exact minute. But it's going to change again, as we'll discuss in a few months. And so what it means is that we all really need to be on our toes and staying in touch with the latest developments, because we are one big citywide litigation team pushing this law forward. And really had huge success doing this, over the last number of years, since ever, but since 2019. And it's had its ups and downs, and we'll go over some of that back and forth. But on the whole, this is basically the only area in law in the United States, really, where the law is moving in a positive direction. So, it's true. So it's like a little oasis with palm trees in the middle of the Antarctic waste, and so we got to enjoy it, right? So
All right. So sorry.
If anybody didn't sign in for the CLE and you want CLE credit, you need to do it now, please. Fordham said not everyone signed in.
If you haven't signed in, use your cameras. All right. I'm going to hit the code. That's the code. All right. And we're going to get started. Okay. I will say that we did update the training since October. What we didn't update is the date on the training. So this is the November version of this training. So the basic goals of this training, the sad thing, if you're trying to figure out if your client is being charged the correct rent, is you have to know both the old rules for rent stabilization as well as the new ones. So we're gonna start the training by quickly going over that. It makes, this is why this training has gotten longer and longer and longer as time has gone on, but as Ed mentioned, these are happy changes. So we're always happy to talk about them. And then to provide a framework for analyzing rent histories and spotting illegal overcharges and deregulation, both pre and post 2019. But before we even start that, what is rent stabilization, right? When might an apartment be rent stabilized? If it's in a building with 6 or more units and was built before January 1st, 1974, as long as it was not legally deregulated. The building has 6 units, which may include illegally subdivided apartments or 2 adjoining buildings combined as horizontal multiple dwellings, or a building receives either J51 or 421A benefits. And so oftentimes you may run into a building built after 1974. Why is it rent stabilized? Keep an eye out for these types of tax benefits. They often bring buildings that would otherwise not be rent regulated into rent regulation for a period of time. So J51 is a tax abatement for existing buildings and apartments receiving apartments and buildings receiving a J51 must be rent stabilized. And if an apartment is receiving a J51 and is rent stabilized because it's a J51, the information
that this isn't a building that is rent stabilized because of the J51. And this is how long that benefit will last, must be in every single lease the tenant gets. And if it is not, when that J51 comes off the building, and theoretically the building is no longer regulated, if a tenant hasn't been given this information, their tenancy remains regulated for as long as they live there. So these notices are very useful. 421A is, and it's also got other names these days. It's 421A 16, and now I think we're calling it 421A W or X. I forget which one it ended up being. But this is a tax credit that new buildings get in New York City. And if the building was built under the original 421A program, pre-2016, all units are covered for as long as the building has that tax benefit. Post-2016, they allow the units to be deregulated on vacancy. And so if it meets the decontrol threshold and it's vacant, those units will not be rent stabilized, but there's a requirement that a certain percentage of the units be affordable. One can quibble about the affordability levels, but the so-called affordable units remain rent stabilized forever. All right, so I assume there are some folks who came into our world post 2019, and some of you have been around for all the bad news. So before June 2019, there were many possible justifications for big rent increases and deregulation. And after June 2019, and it's June 14th, 2019 to be exact, not so much. The world before 2019, there was this law, this rule called the 4-year rule. And what it said was that the legally regulated rent for purposes of determining whether or not an overcharge will be the rent indicated in the annual registration statements filed 4 years prior to the most recent registration statement, plus any lawful increases. So if you filed an overcharge back then, the law was that you could look 4 years back. And if there was a hugely illegal thing that happened 5 years before, you were out of luck, right? That was what the language in the statute said. This is a terrible rule. It led to horrific fraud. And the thing about, and illegalities, and the thing about it, it almost encouraged landlords to do blatantly illegal things, and then hide the ball for 4 years and then admit it because, you know, they got away with it. This strengthening of the law was really put into the law in 1997. So when you're looking at a pre-HSPA, HSPA stands for the Housing Stability and Tenant Protection Act. That's the actual name of the 2019 law. You need to look, if you're looking at a rent increase, you need to understand whether the big jump in rent that you're looking at can be explained by vacancy increases, which was by and large a 20% increase every time there was a vacancy, plus any longevity increase. And then, you know, you want to look at what amount of individual apartment improvements would have to be done in the apartment to explain the big jump you're looking at. And then you want to think about, oh, they say they did IAIs. What does this apartment look like? What might it have looked like at the time, if you can find out from your clients if they've lived there for a while? You want to always go to HCR to look at the rent registrations, but also ask for all the NCI orders and look to see if there have been any rent reduction orders in the time, well, forever. Because rent reduction orders, if you find an old rent reduction order that was never lifted, you're in a really good place in your case. Deregulation, you're gonna do a similar sort of analysis. What were the potential increases that the landlord could have legally taken? And what was the deregulation threshold at the time of the last registration? Oftentimes when landlords say that an apartment was legally or illegally deregulated, you see that as a rent history where suddenly there's no more registration. So you want to look at that time frame and see what the decontrol threshold was at that time. And then you want to do the same thing. You want to calculate what the increases the landlord could take a vacancy, what kind of IAIs would need to have been done in the apartment to reach the decontrol threshold. There are some really good new case law around, I want to look at this while I'm talking, that landlords are required to inform the tenants that are moving in post deregulation with a notice and a rider. It gives them an opportunity to analyze whether how the landlord, tenants are supposed to be given the information of how the landlord got to the rent amount, which gives tenants an opportunity to analyze whether they think the landlord is being truthful or not. And there's a recent very good case that says failure to give that rider may preclude deregulation. And it is, I think it's probably rare that tenants actually get this information. You know, the court in Taylor recognized that high rent vacancy increase of apartments are not supposed to be automatic. You don't have to apply to DHCR to deregulate units, but there are steps that landlords were supposed to take. There's at least one case which suggests that where the unit was not properly re-regulated post-Roberts, Roberts was the case that said that if you have a J51, you can't deregulate apartments. If it wasn't re-regulated after Roberts, they can't then claim to have deregulated the apartment. So they have all these deregulated apartments. They first would have had to come into regulation before you could then deregulate the apartments. And just to, yes, Ed.
You can just put in here for just 1 second. So this is a hot topic here. Whether the lack of a registration or the lack of a rider in itself can stop a deregulation. And there are a number of appellate cases that have kind of seductive language that says the state deregulation was improper because they didn't include enough increases to take over the threshold, and there was no registration, and there was no rider. But as far as I know, there's no appellate case that says they proved that the IAIs were done, but nevertheless, they couldn't get out of that state because of a rider or registration. They suggested, they hinted, and so, but they don't exactly say it. The only case I know of is a case by Judge Golden in Brooklyn, where she actually comes out and says it. Didn't do the registration, you can't get out of the state. But I don't think, unfortunately, the appellate cases quite say what she said. So this is something we have to work on together. I think we can try to look at those appellate cases and push it over but we're not right there. So we're just be a little cautious and not too self-confident that there's a registration high.
That's right. But we should be making this argument. I mean, on a practical level, it may be hard to prove whether or not the first tenant after the deregulation got the notices and the riders, especially because frankly, your client may not have been the first tenant after deregulation. And this is just a reminder of what the deregulation thresholds were pre-2019 because they changed. And so for a very, very long time, from 1994 till 2011, June 15th, 2011, the deregulation threshold was $2,000 a month. And then in a huge victory that we got in 2011, it got moved to 2,500. And then in June 15th, 2015, it got another big jump to 2,700. And then it was indexed to 1 year annual increases from the RGB. And so the last decontrol threshold, which you can find on HCR's website, is some not round number. I would say, I think that the first rent freeze we got was almost immediately after that. So we saw no impact of this rule for 2 years, but it did increase eventually. And this is just what what the rider that tenants are supposed to look like, it's supposed to get looks like. It is supposed to tell you how the rent was calculated. And this is just another notice, just as I said, this is one that where if the landlord did IAIs, they were supposed to tell you where they did the IAIs in this notice. There's a lot of check boxes. Again, I think these mainly don't get sent out, but it's possible occasionally they do. All right. Now that was the sad part of the regulation. Now we're going to talk about half.
Okay, hi everybody. I'm Joanna Lane. I'm a supervising attorney in the Brooklyn office of the Legal Aid Society and Tenant Defense. And I do have the pleasure of starting on an optimistic note with the great new world that we live in post HSTPA. So most importantly, the HSTPA of 2019 eliminated vacancy decontrol. So now in this new world, no matter how high the rent gets, the apartment cannot be removed from rent stabilization by virtue of getting up to that high rent, which is the most amazing change. And it really has done wonders for the preservation of affordable housing in the city. The HSTPA also made a number of other changes. It significantly reduced the amount of rent increases that landlords could take for doing either individual apartment improvements or major capital improvements, IEIs or MCIs. And so there is a fraction of the cost that landlords can take for either an MCI or an IEI, and the fraction is now a lot lower. So you can only take a much smaller percentage of the cost of doing the work in order to increase the rent. There's also a cap on the spending for IEIs, which was changed under the HSTPA to $15,000 for the maximum cap across the building. Now that, more on that in a second, but that was what it was under the HSTPA. It also very importantly eliminated the 4-year look-back rule, which, as Alan explained earlier, allowed landlords to basically hide legal activity for 4 years, get away with it, and then get off scot-free. It's now a 6-year look-back period, but a lot of exceptions to the look-back, and we're going to talk about that extensively in the next few slides from here. There were some other changes. One issue that had been litigated in the courts before the HSTPA was whether tenants have a right to choose their forum in litigating a rent overcharge claim. There had been some case law in the past that suggested that they had to go to DHCR to challenge rent overcharge. And under the HSTPA, it was definitively established that tenants can choose to go to DHCR or raise it as a defense in a housing court case or bring an affirmative Supreme Court case for rent overcharge, and tenants have the right to choose how they want to proceed. The HSTPA also changed the statute of limitations on overcharge claims, which we'll talk about in a minute. Is different than the look-back period. It's simply the statute of limitations, like any statute of limitations or any lawsuit, on how much damages you can claim and how far back you can claim damages. It used to be 4 years. and for regular damages and 2 years of treble damages for willful overcharge. And now it is 6 years of damages for both actual and treble damages, which is a huge change. The HSTPA also eliminated the 20% vacancy bonus that used to exist, as well as the 6.6% longevity increase that used to allow landlords to take an extra rent increase if a tenant had been living in the apartment for a long time prior to a vacancy. And it established that that any preferential rent given to a rent stabilized tenant was permanent. It used to be the case that landlords would offer a temporary preferential rent to a rent stabilized tenant and use that as a way to threaten them and to get away with their illegal activity. So they would illegally jack up the rent by, say, $700, let's say the tenant, but no, it's okay. You're gonna get this preferential rent of, $1,000 instead of $1,700 if you just, keep your mouth shut and don't fight me. And if you do, I'll take it away. And so the HSTPA was critical in establishing that a preferential rent has to be permanent and therefore can't be used as a tool to manipulate tenants. So there was one slight rollback in the rate changes that were made under the HSTPA, and that has to do with IEI rules. So now landlords can collect up to $30,000 of IEI increases during a 15-year period of time, up from $15,000 passed under the HSTPA, that those rules are 180 for relatively large buildings of the cost of an improvement, or for smaller buildings with 35 or fewer units, it's 168th of the cost of the improvement, and no more than $30,000 over a 15-year period. There is also this additional tier 2 category of apartments, which is a sort of small subset of apartments, but has a slightly additional cap of $50,000, up from $15,000 under the HSTPA and $30,000 from the tier 1. And this is for apartments that were timely registered as vacant in 2022, 2023, and 2024. And that they get some pre-approval from DHCR. So this is not a huge category of situations, but it is something to be on the lookout for as it may exist, and give landlords an extra little bit of a rent increase there. So when looking at rent increases after the HSTPA, it is a lot simpler. There are no vacancy increases, no longevity increases. A lot of these categories have been eliminated. It's simply the rent guideline board increase for either a 1-year or 2-year lease, plus a possible MCI order, and perhaps an IAI, which usually cannot exceed $166 for a relatively large building, or $178 for a building with 35 units or less. So much simpler world to live in, and of course a much better world to live in as well. Critically also, there are no more high rent vacancy decontrol. So deregulations cannot be based on the high rent of an apartment or the high income of a tenant, which is also was also an option under the HSTPA pre-HSTPA world. Now, the only real scenario where you can see an apartment being deregulated is if the landlord has alleged that they substantially rehabilitated the whole building. And I won't go too much into this because this could be a whole nother CLE on its own, but just in short, so you know to look out for it. It would involve the landlord making major changes to the overwhelming majority of systems in the building, including the elevator, the flooring in the common areas, the kitchens in each individual apartment, the windows. So in both the individual units and the exterior and common areas of the building, there would have to be a major overhaul, and that often would require extensive discovery and litigation if you were looking at it in court. Well, I do see landlords alleging this more, of course, because that's the one way that they can get out of rent stabilization. So I think we'll be seeing more of that. But it is, that's the only way right now. So that's a much great improvement post HSTPA. There is a rent registration requirement for all rent stabilized apartments, as most of you probably know, having requested rent history. Landlords have to annually register each unit as of April 1st of that year. And if they fail to do that, the rent is frozen at the amount of the prior registration. So that's something to look out for as an additional defense in your cases. If they do register late, it removes the rent freeze prospectively, but not retroactively. And if the landlord registers late, the tenant isn't entitled to a refund for rent that they paid, but they are allowed to raise that as a defense in a non-case. The landlords can't collect the rent increase if they didn't register on time, until, of course, prospectively they can go ahead and collect it. So it's very important for everyone to be ordering rent histories in every single case involving a potentially rent stabilized unit. So potentially rent stabilized unit, as Ellen said earlier, involves not just cases where they're claiming rent stabilization, but also any building that might possibly have had 6 units at one point, maybe illegal units, not necessarily legal units. Any building that might possibly have once had a J51 or 421A benefit. Any apartment where the landlord claims that it's been deregulated or substantially rehabbed, but maybe that's not true. So in short, pretty much every time, be on the safe side unless there's a clear reason why it's not rent stabilized. Order that rent history. And there's 3 general ways to do it. There is a FOIL form that DHCR has. You can send via email to request rent history and also other documents. So we definitely recommend ordering rent reduction orders, MCI orders, and other documents that might be relevant to your case. You can also shoot an email to have a rent history mailed to your client's address, or go in person at the DHCR office. If you're doing it on behalf of your client, you do need an authorization form from your client allowing you to do so. That's applied both in person at the office and via the email FOIL request system. And so it's a good idea to get that form up front if your organization doesn't already routinely do it, as many of them do. But that would be a reason why getting it mailed to your client is an option. If for some reason you don't have that authorization form, you can always have it mailed to them directly. It'll just go straight to their address. So I want to flag that there's a few things to be looking out for when you do get the rent history and other documents on your client's case in issue spotting a potential rent overcharge. There's a few different situations where you might find an overcharge claim. One is the one that we probably think of most naturally, which is if you're looking at your client's rent history and you see a big jump in the rent, or some other irregularity, something that makes it seem like they might not have followed the law. So that's the first and perhaps most obvious scenario. The second overcharge scenario is if your client is in an apartment that was apparently unregulated, but it in fact has 6 or more units and was built before 1974. And you see that the landlord, stopped registering, and there's a big gap between the last registered rent and the deregulation threshold. And so maybe the apartment was improperly deregulated. Or on the other hand, maybe the apartment was never registered as regulated in the first place, but it should have been, and that would be another scenario where you would have an overcharge. And then finally, you might get your client's documents from DHCR and find that they got a rent reduction order at some point in the history of the apartment, and it's never been lifted, and that might be another reason for an overcharge if they've been charging a higher rent. So just very briefly, a rent reduction order is an order that rent stabilized tenants can get if there are repair problems in their apartment. DHCR will conduct an inspection, roll back the rent to the last registered level, and freeze it at that level. And if the landlord charges more than that, there is an overcharge claim to be had. That overcharge claim never expires. It was never subject to the 4-year look back or the 6 concurrent HSTPA look back rules. Our office recently had a case where a rent reduction order had been in effect since the 1980s and was not honored, had never been lifted, and the tenant was able to get substantial damages on that rent reduction order. So that's not going to appear in the rent history. So you also do want to FOIL other documents pertaining to your client's apartment, and in particular to look out for the possibility of a rent reduction order. So if you have a rent overcharge case, you often have multiple goals. If the apartment was unlawfully deregulated, you want to put the apartment back into regulation. You definitely want to return money to clients who overpaid and possibly get treble damages for landlords' willful overcharges. And you want to reset the rents at a more affordable amount. One thing to remember is that although there can be issues of the look back period or statute of limitations with respect to overcharge damages, there is no statute of limitations on challenging the status of an apartment. So you can go back as far back in time as necessary to challenge whether the apartment was unlawfully deregulated. And that was true both before the HSTPA and now after the HSTPA. So you can always challenge an illegal deregulation. If you are successful in challenging an overcharge, you get a lot of great things potentially. You may get a new rent, hopefully a lower rent for your client. In the past, you would have gotten 4 years of overcharge rent, overpaid rent, pre-HSTPA, and now it's potentially 6 years of overcharge damages, including 6 years of treble damages. And the apartment returns to rent regulation if it was unlawfully deregulated. Just gonna briefly introduce the look back rule that we've been talking about and that we're gonna talk about extensively for the next bunch of slides. The look back rule is sometimes confusingly referred to as a statute of limitations, when that is not the case. The statute of limitations has to do with how many years of damages you can claim. As with any lawsuit, that's just the general principle of statute of limitations. The look back rule, although it is sometimes sort of, there's a misnomer of calling it a statute of limitations, it has to do with how far back in the rent history you go to make out a rent overcharge claim. So as I just said, if you have an issue involving an improper deregulation of an apartment, you can go as far back in the rent history as necessary to challenge that. But if you want to claim overcharge damages, or if you want to reset the rent, there's a lot more nuance in terms of how far back you can go. And that's what this next section of the presentation is going to talk about. So with that, I will turn over the microphone to Ed.
So this is for those who, this is probably all of you have litigated rent overcharge issues. This is the issue that sort of keeps us up at night. This how to deal with the 4-year statute of limitations, with what was the 4-year statute of limitations. And I just want to take one half step backwards. That looked at as a whole, the 4-year rule was part of the system under the 1997 Reform Act that incentivized displacement against tenants, because one part of that rule was if you could, that rent increases for tenants in place were held relatively modest, even though people fought over the dollars every single year. They were very small compared to the increases that labor paid 20% IAIs were astronomical compared to the guidelines in place. And at the time in 1997, there were those in the tenant movement who thought that it was kind of an acceptable compromise because tenants in place were protected. And for a tenant in place, if you go, who cares about the person who comes after me? But they quickly realized that that was not the case, because by putting an incentive, by allowing these massive vacancy increases, they created a huge incentive for landlords to turn over apartments, which meant to evict the tenants for those apartments. And so, far from protecting tenants, it really undermined not just, it undermined the security of everyone's tenancy. And so part of that was the vacancy increases. The second thing was the deregulation, if you could push the rents up high enough to the threshold. And then the third thing was, the first two things were if landlords did it right and followed the law, and really did the IAIs and got the increase. And then the third thing was the 4-year rule, which allowed people to violate the law and get away with it if they could go past the 4 years. So those things together meant that we saw many hundreds and thousands of frivolous holdover proceedings, chronic rent delinquency, which I don't think any of us see anymore, many more non-primary residence cases, frivolous nuisance cases. And I think the HSTPA really did its job in reducing, not eliminating, but reducing that kind of pressure on tenants. Or the other thing we'd see all the time was non-payments would get into court and say, let's do a step up paying rent, and say, we don't really want the rent, we want you to plan it out. And I think we see at least somewhat less of that now. So what the HSTPA did by eliminating the 4-year rule is that, at least going forward, it eliminated the incentive for landlords to commit fraud, because now those who violate the law, and there always be somebody do that, have to know that no matter how far in the future it may be, they will never be safe. And one day they will run across a legal services lawyer who will catch them out, and then they will be stuck. We have damages, especially because now it's 6 years of travel is not. But the new, let's go right now. So I don't do, and the new rule, totally changed the paradigm. And the idea was that even though you could only get 6 years of damages, you could look back basically as far as you wanted to challenge suspicious and improper cases. And the way the rule was written, it didn't eliminate the look back rule. Oh, you can't hear, I'm sorry. It didn't eliminate the look back rule, but what it did was it said, you look back 6 years, and if that 6-year registration is unreliable for any reason, then you can keep looking back. It could be 10 years, 20 years. There's nothing in the statute that said, how limited how far back you could look until you got to a registration that was reliable. And what did reliable mean? Well, the statute did define reliable, which meant that you had a lot of leeway to litigate what was reliable and what was not reliable. But the basic shorthand was, if there was some big mysterious jump anytime, anywhere in the rent history, you could say that made everything subsequent to that unreliable, and you have to look back. So that was a wonderful rule, and lasted like less than 12 months, as people probably know, because the Court of Appeals, basically the landlords, they had lost control of the legislature, so they turned to the next best friend, which was the Court of Appeals, and Cuomo's appointees to that body, and got themselves a decision that said that the Part F of the HSTPA could not be applied retroactively. So basically, at least on the face of Regina, you could only go back to 2019, and only be go back further than 2019 is if you had filed an overcharge case, let's say in 2020, and then you go back 4 years from that, go back to 2017. But for subsequent cases, it seemed like Regina was a very strict bar to going back into correcting all of the fraud and that scandalous rent inflation that occurred prior to the HSTPA, which is of course exactly what we're hitting the HSTPA to do. So it's very, very frustrating. But the happy story is that yes. Yes, there's the genes like this. Okay. And there were, so one thing that people have been thinking, so obviously this was a big obstacle, but of course, we all put on our thinking caps and thinking, how can we punch loopholes in Regina? And so one of the first loopholes that we were thinking about was that Regina was very concerned about the poor landlords who had under the old system, were allowed to throw away their records after 4 years. And everyone who was litigating at the time can tell you that they never threw away records. They would move for discovery, they would oppose discovery, and say, oh my God, it's too burdensome, it's outrageous, because we're allowed to throw away our records. And the judge would say, okay, discovery is granted, and then there were the records. Well, they never threw away records, and especially records on PDFs, and they were physically thrown away a PDF. And so we always had the records at the end of the day, but the Regina court thought, oh no, throw away the records, and it would be terrible to penalize them with these terrible draconian onerous penalties, for just doing what the law said they could do, which is the records. But there were some people who said, well, but on the date of the HSTPA in 2019, landlords knew they were supposed to keep 4 years worth of records. So they should have had their 2015 records. They shouldn't have thrown those away. And then once the HSTPA came along and said, don't throw away your records. Actually, the HSTPA says you can throw away your records. It actually says that. But it says that if you throw away your records, it's tough luck for you if someone challenges. So basically, they were on notice that they would always have to defend the 2015 rents. So people said, so, if does it make sense that even despite Regina, consistent with the reasoning of Regina was that you should go back not to 2019, you should be able to go back to 2015. And that makes so much sense. But unfortunately, there were two appellate division decisions that did not go that way, and they, without any reason whatsoever, said that basically you can only go back 4 years from, so if you did a 2020 claim, you can only go back to 2017, not 2015. And so that's where things stood for a number of years. But those were 2023 cases, 2022 case. But the law was still evolving when DHCR came out with its amendments to the stabilization code. This was intended to kind of flesh out and effectuate the 2019 HSDPA. It took them 4 years to do that. To be fair, partly is that they were working on it, and Regina came along and totally changed the whole landscape, so they had to go back to the drawing board and redo their amendments. And so they came out with a new rule which is codified a new section of the RC 2526.7. Is the kind of everybody's favorite number now, and which was not it's way better than we thought it was going to be. And so what the new reg says is that you go back. Your basic is you look back 6 years from when you're filing your claim, but if the 6-year registration is not reliable, just like HSDPA says, you can look back to previous years. As far back as June 14, 2015. And they don't spell out why that number, why June 14, 2015, but it's obviously because it's 4 years prior to the HSDPA, and the implicit reasoning has to be what I was just talking about, that landlords were on notice, not just related records. And so the RSC now embodies that reasoning. And the other thing that it does, it defines reliable, which the statute does not define. It defines it in a very simple, easy way. And like how often in rent stabilization you can simple and easy, but here is the one exception. Here it is, and it says that a registration is reliable if there were no unexplained increases between that registration and 2015. So you look back, and so what is that? So what does unexplained mean? Well, that's easy. Unexplained means if there was a jump and it's 20% in between tenants, then that's explained. If there's a guideline increase, that's explained. If there's anything else, then it's unexplained because the eyes aren't spelled out in the registration, so we need an explanation. So basically, you can go back to 2015 anytime you would want to. You would want to if everything's explained. And so, again, this is not as wonderful as the HSDPA, but we should just pause to realize that this is pretty damn good, because here we are in 2025, and we can now look back 10 years. And that's pretty good. 10-year statute of limitations, and where do you have that outside of this? So, and every year that goes by, next year will be 11-year statute of limitations, then it'll be 12-year. So it's only going to get better, right? And we'll always be able to go back to 2015. So we've got to appreciate that. And that is a pretty good rule. And we become more and more frequent when we need to go back beyond so an example, so here we are today in 2025, you can go back 6 years to 2019, but then if there's an unexplained increase, you go back to 2015, so you go back 10 years. So that is good. And the best thing about using 2526.7 is that previously, to go back more than 4 years, you had to allege fraud. We talked about fraud a bit, but most people are familiar with the concept. You had to put something more than just an unexplained jump. You had to have an indicia of fraud. And those were mysterious and elusive concept that was fought out over this immense like 20-year period. 2005, 20 years of litigation. And it was a mess, you know, it was no fun. And courts went every which way, appellate courts went every which way. Sometimes you got discovery, sometimes you didn't. You know, it was a huge undertaking to often to litigate fraud. And here, you don't have to say one word about fraud. And so that's a very, very big thing. And so I'm going to talk in a second about, you know, those cases where you really, really, really want to go back before 2015, and you have to start thinking of other possibilities. But when you have an overcharge case, before you go down that kind of hard road, you really want to give a little thought to how much more are you going to get on the hard road than on the easy road, because this is a really easy road. You know, so, and you know, it varies in every case. So you have to look at the rent history and how much the rent, you know, the increases prior to 2015 really were. You have to think about what you're trying to accomplish in the case. You're trying to get the rent down to the employee effects level, or, you know, do you have a working client? You really want to get the rent down all the way. How much risk does your client take? How long? And a lot of fraud cases go on appeal. I mean, all those things. And so now, before that, we had no option. We just had to go into that, you know, fraud battle. But now there's an easy route, and so we just want to weigh in our minds, you know, like, it's great to want to do it, and it's slightly difficult. But it turns out that there are other options, because things got even better after 2023 when we did the code. Surprisingly to someone else, but it was a particularly dogged attorney who litigated the Respierre versus Harvey case, and and he refused to accept this rotten compromise that was included in the 2067. No, we should be able to go all the way back, you know, just like the HSDP has said, at least when you are trying to calculate the rent going forward, because Regina was very, because as the argument goes, Regina was very concerned with landlords being hit with draconian penalties for conduct that was legal at the time it was done prior to 2019. But that really didn't apply when you're talking about rents collected after 2019, because those rents were not legally collected. And so there's no, retroactive constitutional problem. And so what you want to do is reset the rent post 2019. You should be able to look back as far as you want. And a little surprisingly, the court in Harvey bought that argument. It seemed to buy that argument. What the allowed Seth to do was to look back at an increase that occurred in 2014. So it wouldn't have been allowable under the Rent Stabilization Code. It was allowable under this theory that you're seeking prospective damages only. Therefore, it's not a constitutional, it doesn't implicate the constitutional problem. And as always with these good decisions out of the appellate courts, it's not written in the most clear and lucid way. And so what the court in Harvey did was it listed out a bunch of facts, but didn't quite say which of those facts is the key facts. So in Harvey, the tenant moved in 2020, so she wasn't even there. The HCA, and the court notes that once this is she moved in after 2020. Her damages are all after 2019, therefore, Regina doesn't apply. So I'm hearing that there are courts now that are saying that Harvey doesn't apply unless your client moved in after the HCA. It doesn't really make sense because what's important is that you're only seeking damages after 2019. If your client moved in 2017, but you're only asking for post-2019 damages, what difference does it make when she moved in, right? It makes no difference. But courts who are uncomfortable with the result of Harvey are going to be looking for reasons to limit Harvey to its facts. And so that is going to be the hottest of hot topics going forward. Can we really is also, there's a motion for me to go to the Court of Appeals. My guess is that if granted, it's a really significant issue. I'm optimistic that the current Court of Appeals will hold the appellate division on this, especially since there's so many people in the court now who are dissenters of Gina. But we don't know. So for now, Harvey gives us all an argument. We need to go back before 2015. That we can go back to that. Let us go back and examine the old increases. And if that works, if this holds up, then Regina is going to be pretty close to a dead letter, because the only time that the Regina rule would apply was when someone was seeking damages prior to June 2019. But we're sitting here now in November 2025, so 6 years of damages, all post-HSTPA. So the only people who will be seeking pre-HSTPA damages are people who already filed overcharges, right? And that's going to be an ever smaller number of people that we're going to encounter. And so if Harvey holds up, that'll be a nice world to be in. So I haven't talked about this slide yet. So really limited, we'll put a case, again, the second part will go a different way. And most likely the second department is unlikely to go a different way because they've already gone a fairly similar way. So I think that's the last thing I'm going to talk about before we move off the stage here, is the Silman case. And the Silman case is a very kind of peculiar and complicated idiosyncratic case that involves a building. It used to be Michelin, and then Michelin turned into Rent Stabilized, which is not the usual fact pattern that we see. And what Silman said was that, as in Harvey, you could look back before 2019 to examine rent increases as long as you weren't asking for damages. And in Silman, what's peculiar is that the tenant wasn't looking for any damages at all, pre or post, nothing. And so the question is, does Silman mean literally that then you can't get any damages if you are trying to look back before 2018? And Silman doesn't answer that question because the facts were the tenant did more damages. But arguably, Silman should apply just as well if you're seeking post-HSTPA damages instead of no damages, because the same principle applies. There's no retroactivity if you're not asking for retroactive damages. So I'm not going to actually go through all the facts in Silman because they're weird. But the bottom line is that Silman is also motion pending the HCR cycle to the Court of Appeals. Mr. Silman was actually pro se in the appellate division. And so legally we didn't need this in opposition to the HCR's motion, and see what happens. And someone will have to do something in the Court of Appeals with us to make sure that he's not there by himself. So the last thing is, is we talked about already. So what do you do if you want to challenge an old increase but you also want damages? And so one possibility is, depending on how Silman goes, you might have to say, well, you choose between damages and lowering the rent. And that might not be a terrible thing. You get a one shot for the years, and then you drastically reduce your tenant rent going forward. That might be a thing to do. But we don't have to do that yet because Silman hasn't told us to do it in the second department. The other possibility is to ask for two two different percentages of damage. You use to compute the post-HSTPA damages, you can look back as far as you want, and to the extent your claim is a pre-HSTPA claim, you would use the old law to compute that. But think about that a little bit, right? Because you have to use not just two calculation methods, but to calculate the old damages, you would probably have to litigate an entire fraud case to get those damages. And so that means discovery, and it means, like bitter arguments over what is judicial fraud. And so again, the question is how much damages, how much is the little bit that overlaps for 2018, how much you're going to get in exchange for how much of a fight you're going to have. I'm not saying you shouldn't do it. In many cases, it's really important to find for those reasons to have that fight. But we have the luxury of at least considering maybe we don't need to have that fight. Maybe we're going to, do quick and dirty and get that rent down for our client and get the respectable amount of damages. Let's say, we've got a 2024 claim and we can get 5 out of 6 years or 5 years of trebles. How much do we want the extra when you singles, right? So just something to think about. So that, come back over to Joanne.
We're going to talk about a few general exceptions to the look-back rule, and these all have nothing to do with the HSTPA. These have all been exceptions to the look-back rule from far before the HSTPA was passed. They often, if you're looking at old case law, you might see them described as exceptions to the 4-year rule, but whether now that we're not in a 4-year rule scenario anymore, it still applies. It's still an exception to the look-back rules post HSTPA. If you have an exception, you don't need to worry about Harvey, Regina, or any of what we just talked about, or any of the rules. So one key exception, as talked about earlier, is that if you are arguing about whether the apartment was unlawfully deregulated, you do not need to worry about the look-back rule. There is no look-back there's no statute of limitations or look-back rule for questions about the rent stabilized status of an apartment. And one of the early pieces on this was called East-West Renovating from 2005. And that set out that rule, which has been followed consistently, and including in Regina Metro, they acknowledged that they were not disturbing the long-standing rule that if you're challenging rent stabilized status, there is no look-back period. That being said, just because you have an apartment that was allegedly deregulated doesn't mean you can completely ignore the look-back rule, because you might have to worry about it for the question of how the rent is set, and you might have to worry about it for the question of how much damages your client is entitled to. So you might still have to worry about the look-back rule, but at the very least, you should be able to get your apartment back into rent stabilization without concern for the look-back rule. There are 3 other exceptions I'm going to talk about. One is if there is a rent reduction order in effect. One is regarding analysis of preferential rent agreements. And third, if there's a vacancy on the base date. So first, as I said earlier, if you have a rent reduction order that has been placed by DHCR and was never lifted, and the landlord has not been honoring that rent reduction order and has been collecting a higher rent, you have a rent overcharge claim no matter how far back that rent reduction order was, even if it was placed in the 1980s, 1990s, early 2000s. If that rent reduction order is still in place, you can challenge it, and you can collect up to 6 years of damages, including treble damages for that overcharge, regardless of how long ago it was. And this comes from a case in Trome v. Colahero from 2010, and it's still good law today. The next exception to the look-back rule is when you have had a preferential rent agreement in the past. So this is concerning the old world in which preferential rents could be taken away pre-HSTPA. There were 2 types of preferential rent agreements back then, and it was a question of contractual interpretation, whether the preferential rent agreement was meant to be permanent in the sense that your preferential rent could only increase by the Rent Guidelines Board increases year after year after year. And some preferential rent agreements pre-HSTPA were worded that way. But the landlord also had the right to give you a preferential rent that was for 1 year and 1 year only, or one lease only, that could be taken away. And so, there is, law that says that the court may examine the preferential rent to determine if it was meant to be permanent, and that can go back as far back as you need to go. And third and finally, if there was a vacancy on the base date, so right now that's a 6-year base date, if there was a vacancy on that base date, then you can go back, and recalculate the rent as you need to, depending on 1 or 2 rules that existed. So there was a rule pre-2014 that said that when an apartment was vacant, on the base date, the next rent would be the first rent agreed to by the next rent stabilized tenant that came into the apartment after it was vacant. And so basically whatever that tenant was paying, whatever they were actually paying, not the legal regulated rent, but whatever that tenant was actually paying, would be considered the legal regulated rent pre-2014. And then the current rule post-2014 is that it's basically a calculation of more or less what the rent could have been increased to if there was a tenant in place. It's a little bit complicated, I won't sort of go into detail here, but you can look at the regulation and do the analysis if you need to. And if there is a vacancy on the base date, you can go back and analyze those vacancy rules in that way. I think that's the end of my brief section here, and I'll turn this over to
So, for many, many years, the majority of this training would be on the fraud rule. We now have so many more tools to attack old increases, that this part of the training has gotten smaller and smaller. But we still need to be able to, we probably still need to, especially until we see what happens to Harvey when it gets up to the Court of Appeals, we still need to think about the fraud rule. And certainly if you filed a case like I did in 2018, where the case is still ongoing, fraud becomes very important. And just so you know, I know we think things are slow in housing court, but Supreme Court is so much slower, I cannot even begin to tell you. Anyway, so when do we need to plead fraud? And for those of you who haven't spent time focusing on fraud, what is fraud? The fraud exception was actually created by the courts to allow tenants to go back to more than 4 years to challenge an illegal rent increase. Basically, in 1997, the legislature tightened up the 4-year rule, and then the court spent a really long time having very blatant fraud come in front of them and having to say, there's nothing we can do. We can see the landlord has done all sorts of illegalities, but they're home free. And I think that really bothered the courts, because that's not the way they think of as being, courts that consider equity, and their hands were being tied. And so they created this 4-year rule. We're in this weird situation and talking about this in 2025, because any one of you who files an overcharge case tomorrow, all of the overcharges will have accrued post HSTPA. So you should, right? So you should be able to use the Harvey rule. But because we don't know of Harvey's last word, it may be strategic when you're pleading to consider also doing an alternative. There's been a fraudulent scheme to deregulate. So until we get the last word from the Court of Appeals on Harvey, we're going to be in this moment where we may want to do some more thinking about fraudulent schemes to deregulate. Oh, sorry. So what is the fraud rule? The thing to think about this fraudulent scheme to deregulate is it's about a fraud on the system, right? It is the idea that there was this whole regulatory system, and landlords were basically ignoring it and charging whatever they wanted to and getting away with it. And the courts that offended the courts. And so they looked for evidence of a landlord's fraudulent deregulation scheme to remove an apartment from the protections of rent rate stabilization. The rule was to allow you to challenge the base state rent that was back then the rent 4 years beforehand, where a fraudulent scheme to deregulate taints the reliability of the rent on the base state. And when you are successful in a fraudulent scheme to deregulate case, the way you determine what the rent should be is based on the default formula. And all of this comes from a case called Grimm versus DHCR. Although the first case to talk about the fraudulent scheme to deregulate, Thornton v. Barron, was a couple of years beforehand, Grimm was the one that really told us all how we should be thinking about fraudulent schemes. As I said, these were court-created rules. The cases that you should be looking at if you're thinking about this are Thornton v. Barron, Grimm v. DHCR, Conason versus Megan Holdings, and Boyd versus DHCR. Those were the pre-Regina, the cases that, not that Regina was a fraud case, but the cases that sort of set the fraud rule from the Court of Appeals. So we have this rule created by the courts. It was codified by the code in 2014, everything was humming along. And then Regina came along, and Regina was not a fraud case. Everything in the Regina, what the court said in Regina is this is not a fraud case. They seemed to uphold the fraud rule and then dropped a footnote with the definition of common law fraud. And so we went through this wild ride for a number of years. I see a lot of nods if you remember this wild ride. And where we had to figure out how to prove common law fraud, which really doesn't work with the rent regulation system. And so while waiting for the court to weigh in on whether the first apartment was right, that no tenant would ever be able to make out a cause of fraud, we went to the legislature and asked them to overturn the case, which they did. These laws, and you see the site at the top, it says L 2023 and L 2024. These laws are still session laws. They weren't codified as anything. And so you just have to know the site. But basically the law was an attempt to break us out of the Regina, what is common law fraud, and get back to the fraudulent scheme to deregulate that was created in Thornton and elucidated in Grimm and the other cases. And what the law says is when a colorable claim that an owner has engaged in a fraudulent scheme to deregulate a unit is properly raised as part of a proceeding in court or HCR or whatever, that court or HCR shall issue a determination as to whether the owner knowingly engaged in such fraudulent scheme after a consideration of the totality of circumstances. And totality of we used to talk about indicia of fraud, now we're talking about totality of circumstances. It's all the same thing, right? So when you read cases pre this law, pre-2024, they talk about things, we're back to the old rule. I will point out that there are two parts of this law, one found in 2023 and one found in 2024. Basically, the law that the legislature passed was better, but the governor wouldn't sign it as such. And so she negotiated for the language we ended up with, and that's in the 2024 law. But in the 2023 law, there is a whole series of findings. The findings section might be useful in your cases. And so the way you have to read the law is the findings section and then the language that was put in the 2024 session laws. And so what I have up here is what the findings section says. And so, as I said, the purpose of the statute is to return the fraud rule to the pre-Regina rule. So when you go back to that old rule, or the old Grimm rule, the old the pre-Regina rule, when you go back to that, there's it's actually just a Supreme Court case called Pearson. But Pearson laid out what are the factors you should consider when considering whether there's been a fraudulent scheme to deregulate. And then DHCR and courts just picked it up. And so we talk about these Pearson factors. And so the tenant has to allege the circumstances that indicate that the landlord violated the rent stabilization law or the code, in addition to charging an illegal rent. Right, so you need to show some other illegalities involved in what happened to get to the illegal rent. That the evidence indicates a fraudulent scheme to remove the rental unit from regulation, and that the rent registration history is inconsistent with the lease history. The courts are supposed to look at all three factors. You don't have to have all three of them to show a fraudulent scheme, but you want to be considering these three factors when you're making your case. And so here are a bunch of examples of what they when the courts look at this. Rent jumps, missing registrations. Missing registrations is actually a pretty easy one to find. It is really not unusual in these cases to see years where registrations just weren't there. Blank spaces in lease writer, 1,000% increase plus an illegal partition, fictitious tenants being created, a lot of misregistrations. It's very useful. And so, it can't be just one thing. And this is particularly apt because of the 4 cases with creating the fraudulent scheme to deregulate, 3 of them the tenant was successful, 1 of them the tenant was not successful, and that was Boyd. And in Boyd, the Court of Appeals says that a mere increase prior to the base date alone is not a sufficient basis to investigate fraud. So you need more than just a jump, and that's when all this other stuff, including the missing registrations, shows you that more happened. There was briefly a question about whether in a fraudulent scheme to deregulate, did you need to show regulation or just an inflated rent? And it's seemingly been answered by a case from April of the First Department, saying that just because the apartment had increases in rent but hadn't reached the decontrol threshold, that the landlords can't defend against a fraudulent scheme to deregulate by saying, well, the apartment wasn't deregulated. That if the landlord is trying to get to the decontrol threshold by these inflated rents, that's enough to meet the standard. We have a second department case where the court found that the new language in the statute is constitutional. The bad part of Gomez is the court seemed to find that in the J51 context, where the landlord claimed confusion about the law, you can't make a case that there was a knowing fraudulent scheme to deregulate. And I would expect a lot more landlords to start to claim confusion. I'm not saying they're not often confused, but I think we're going to have to make a case that, landlords' intention just to remain confused is not enough for them to successfully steal money from their clients, from their tenants. So, after Gomez, what do we do with this new confusion, defense? Can we limit it to this J51 area, which is, Regina was a J51 case. That is an area where there was a lot of confusion. And so maybe we can say this, maybe we can limit the cases that, where landlords can use this defense. Things like landlords lying about IAIs or creating a ghost tenant so that they could get vacancy increases would seem to fit poorly with the idea that the landlord was confused. And then there's a case that is currently pending at the Court of Appeals called BU Realty versus RS, where it was a case in a building where the landlord had done a lot of building wide attempts to deregulate units. And they had actually done that in all of their buildings. And the first department confusingly said that they wouldn't take into consideration. It was a case where the tenant had succeeded on a summary judgment motion. The landlord appealed, and the first department found summary judgment for the landlord, finding that they had failed to make out a case because you can't consider what had happened building wide in making the case that the landlord was engaged with a fraudulent scheme to deregulate. You have to go unit by unit, and they didn't see anything problem with the landlord doing the same thing unit by unit. But that case is currently at the Court of Appeals. So we should see what the Court of Appeals thinks of these arguments. And I'm gonna turn this over to Joanna. Oh, I missed one? Okay, part of the this actually might be part of the so, but that's yours. Yeah. There are different rules for rent setting after an overcharge finding or illegal deregulation, which may explain how the landlord rules. All right, default form.
Yeah, so, it's all.
Yeah, no, I got it. Thank you.
So basically, when the default formula applies, almost entirely when you still have a fraudulent fraud claim. The other example is where there is no registration at all, no information on the base date, and sometimes the GSR will apply the default formula back. And so what is this mysterious default formula? It's first recognized in courts in Grimm versus Gordon versus Barron. When you don't need fraud, you go back to the base date and you recalculate all the rents going forward using the guideline increases. But when you're using fraud, what Thornton said is you can look back before the base date to see whether or not there was fraud, but that doesn't mean that you can then go back to where the fraud was and then recalculate everything. You go back to the base date and reset the rent using the default formula. The default formula was one of a number of mysterious formulas and rules that DHCR had at the time that were not written down anywhere. If they were written down, it was in a public-facing way. It was kind of amazing. So, from the term that you can use it since like 1974, but never told anybody about it, never showed it to anybody. It wasn't in the code. And so, but I guess they put it forward in the Thornton case, and so the court knew about the default formula. So then what happened was in 2014, DHCR, and I forget why it was, but decided to revise the rent stabilization code to reflect the past decades of.
They were obligated by law. 2011.
Oh, 2011 said you have to revise the code? There you go. So 2014, they revised the code, and they, for the first time, wrote down the default formula. What what's interesting about the default, the thing that wrote down in the code is it's different from the default formula that were discussed in Thornton versus Barron. And so what it says is, now you can all read it because it's there, is that it's a series of choices. And you get to look at this menu and you get to pick the menu item that results in the lowest rent for your client. So you get the best of all of them. And the number one on the list is you look back and find the lowest rent for a comparable apartment in the building on the date your client moved in. And this is important. It said you look back to the comparable apartment on the base date, which could be very different from when your client moved in, which could be decades before the base date. And somehow HCR did not notice what it was doing, and no one else seemed to notice either. It was odd. It was not really discussed in the case law at all. But here you've got, it's a fraud case. You're not supposed to be looking back before the base date, but the code says you can look back. Okay. So you should use it for what it's worth, but be aware that there's something weird about it. And it's arguably not completely consistent with either Regina or with the thing before. But here it is. So you look back, and how do you know what the lowest rent is in a comparable apartment? Because obviously your client's rent history is going to tell you that, and rents for apartments where your client does not live is, of course, keeping confidential under the Rent Stabilization law. So the answer is you have to discover it, basically, to get it. And sometimes you can subpoena the building-wide rent roll, and TCR will produce it, but even that will not tell you which apartments are comparable and which ones aren't. It'll just tell you every apartment in the building. So you still need at least a little discovery to tell you which apartments are comparable in the same size. And then you look back to the year when your client moved in, and then you pick the cheapest apartment. And so sometimes that's great. It's a huge windfall for your client because there was someone who was in there since 1968, and they have a really low rent, and then that's your client's rent. But in other contexts, it's not so great for your client because you could have a building where the landlord was hell bent on pushing people out and inflating the rents. And then you look back and it turns out everybody was paying an outrageous rent, and that's not so great for your client. Especially that's going to be true in small buildings where you really push people out. So then you look at the next thing, which is you go back to the client's initial rent and you reduce it by 20%, roll it back the vacancy increase. And so sometimes that can be really good, especially if your client moved in a long time ago. Then you're really going back far in time and reducing 20%. And that can be so much easier than doing discovery and finding out what the cheapest rent in the building was. And so if you have a number you like, then you can just do summary judgment on that. And that might be a preferable thing to do. And then the other prong is the last registered rent paid by the prior tenant, which again is far before the base date. And then there are some circumstances where all the rents in the building, you just don't know what they are. Like, let's say the building was never registered. A good example of that is de facto rent stable buildings. When you made a judgment that the building was rent stable all along, but the landlord didn't think so. So it's never registered, no records, no nothing. So how in the world do you apply the default formula? And the answer is that you're supposed to use another secret procedure that the HCR has been hiding all these years. That's using sampling methods. Sampling methods are trained by the HCR that I don't know, sample, it doesn't really, I don't know what you even sample, but sample apartments in the neighborhood, in the world, on planet Earth, it doesn't say. And unlike the default formula, it's not written down in the code, it's not written down in an operational bulletin or a policy statement or any of those HCR things that you can sometimes get. I have never seen it. I don't know anyone who's ever seen it. No one's ever seen a THCR decision that uses their sampling method. And so, it's like one of those things, it's sampling method samples, and no one sees it, it's really a sample. I don't know. And the worst thing is that how are you going to ask a court to use this prong of the default formula if no one's ever seen it? And so I don't know anyone who's had any success with this. Hopefully, again, if Harvey comes true, we may not have to use the default formula anymore. We may not have to, and this prom will just disappear, or someday someone may subpoena the HCR to come to court with their secret formula. We should do that for fun sometime. Let me know if you're the one who does it. So that's the default formula. So now,
Okay, so I'm gonna close this out by talking about litigation strategy, and we really are in the final stretch here before we turn to questions. So the first thing to know is, of course, always review the rent history before amending your answer in a non-pay or interposing one in a holdover, and especially before settling your case. So even if you have to request an adjournment, even if you have to grovel for an adjournment because you haven't yet gotten your rent history, it's worth doing so rather than potentially missing out on a rent overcharge claim. If your client comes to you and they've already signed a stipulation pro se or defaulted on a case, you should know that the existence of a rent overcharge claim is a very strong excuse for vacating stipulation or making a default. And then assuming that you've set out your rent overcharge case and you're beginning to litigate it, people often move for discovery, and particularly if the landlord is claiming individual apartment improvements as a basis for a rent increase, or is claiming something that happened in the past history of the apartment before your client moved in, different tenants that had rent increases at one point or another, you might want to move for discovery to find out what actually happened, what was the rent actually charged to prior tenants, what improvements is the landlord claiming that they did, and did the tenants, in the past receive the appropriate riders that were required under the law. So those are all good reasons for moving for discovery in a rent overcharge case, and discovery is generally liberally granted. There's a lot of good case law holding that discovery should be granted in an overcharge case. But I want to posit that you should also consider moving for summary judgment, at least in some before discovery, perhaps in certain circumstances. And those cases would be scenarios where the rent history is just obviously wrong. For example, a landlord registered the apartment with a legal regulated rent in 1 year of $1,075, and then the next year it jumps up to $1,900 with no explanation given. The landlord is required to list if they claim that they are taking IAIs in a given year. They're required to put that in the rent history. So it's not in the rent history. It would be my position, at least, that you can move for summary judgment on that and say that there's a facially evident overcharge based on these improper rent increases. It's debatable. You may prefer to move for discovery anyway because you don't want the landlord turning around and saying, oh no, we meant that we took these IAIs. You might want to just try to get that information from the landlord, but you might not want to prolong the litigation, or for any number of reasons it might give you the upper hand to jump immediately to moving for summary judgment if it looks like the facts in your case are quite clear. So those are some things to think about. If you do move for discovery, then you could, at that time, once you've gotten discovery, you probably can move for summary judgment, and that's usually how most rent overcharge cases go. You get whatever discovery you get, and then on the papers, you would make your motion for summary judgment, because at that point, all the evidence is in front of the court, and it's really just a question of legal interpretation. You should not typically have to go to a trial for that, unless there's a really hot dispute over maybe the sufficiency of the landlord's IAI evidence or some very fact-heavy situation. A couple of notes on drafting your answer. You might plead overcharge in a few different ways. I would definitely recommend that you don't just list rent overcharge as an affirmative defense, but also be sure to list it as a so-called objection in point of law, to point out to the court that it is the landlord's burden of proof to show that they have properly registered the apartment, that they're not overcharging the tenant, and in a case of deregulation, it's the landlord's burden of proof to show that they have lawfully deregulated the apartment. And so, stating it as an objection in point of law is the way of flagging to the court that this is really the landlord's prima facie case that you're talking about. In addition to any defenses you have, you also want to potentially raise overcharge counterclaims or rent overcharge damages, which are not inherent to your defense. You have to separately raise it as a counterclaim if you want to want to collect additional damages for rent overcharge. And you might want to toss in a claim for harassment, because charging an unlawful rent, at least knowingly, is a form of tenant harassment, and that can entitle your client to additional damages. At the very least, the $1,000 in statutory damages that's allowable under the harassment law. You want to make sure you plead with enough specificity to set out your claim, but without boxing yourself in. And that's an art, not a science. I don't really have any tips beyond that, just things to think about. And you may want to plead several different theories in the alternative. As Ellen talked about earlier, even post Harvey, we may not need to prove fraud, but you might still want to do so just in case, say, Harvey is reversed. Or you might have different issues with different timeline. You might be challenging unlawful deregulation, so you don't need to deal with the 4-year look back at all. But you also want to have the rent set favorably for your client and have good damages for your client, so you may need to go into some other analysis of the look back period, even when you have an unlawful deregulation case where, strictly speaking, you don't need to worry about the look back period. So think about what you might need to plead in the alternative when you're drafting your answer, and your answer really truly might be a little bit lengthy for that reason. It's okay to do that, but you're trying to strike the balance between saying enough to make your claim clear to the judge and to your adversary without locking yourself into one particular theory. And finally, don't forget to state all of the relief that you're seeking, especially because there are a lot of things that you can get in an overcharge claim. So be sure to specifically plead a request for treble damages based on the owner's willful conduct, as well as your claim for attorney's fees, interest, and so on. In terms of the different remedies that you can get a variety of things. You might be first seeking to get your the landlord's case dismissed against your client. You're looking for damages, which post HSTPA is up to 6 years of damages and including 6 years of treble damages. And then you also want to look out for the option of getting attorney's fees in your case, which means that we can be keeping time and collecting fees for our organization. So as I noted at the beginning of the presentation, tenants can litigate an overcharge either in court or DHCR, and it's completely their choice. And they have the right to withdraw. If they have filed in DHCR, they have the right to withdraw their DHCR claim and then litigate it in housing court instead. One thing to think about there is that if they are withdrawing their DHCR claim and refiling it, they might be setting themselves up for a later period for statute of limitations purposes, so that might limit the amount of damages they can take, but that is something that they have the right to do. And so when we're considering with our clients whether it makes sense to go to DHCR or proceed in housing court, there are various considerations to think about. So DHCR has a few disadvantages. They are reluctant to find a fraudulent scheme to deregulate an apartment. And more broadly, I would say they're just not necessarily the most tenant-friendly body, and so you might have a better luck before housing court or Supreme Court judge. They're slow. They're very slow. They anecdotally, I filed a rent overcharge complaint once, and I got a decision 4 years later. So it's just not that court moves so fast either, but at least you're seeing things happening throughout all that time. And DHCR is just a black hole, and you may never see the light of day with that case. And then in the meantime, if your client is at risk of eviction, of course, you have the issue that many courts will not stay an eviction case pending the outcome of DHCR a decision. So if your client's case really depends on an overcharge, it almost definitely makes sense to raise it as a defense in housing court, not at the DHCR level. But perhaps there might be scenarios where your client's overcharge claim is fairly minimal, and maybe they receive a subsidy, so it doesn't really affect them on a daily level. It may, and maybe they really just personally don't want to, they're not really looking to be in housing court litigating this for a long time. They'd rather just file it passively and let DHCR do what they're going to do. And that's a valid, position for your client to take. And we should always, talk it through with our clients and honor their decisions. But in many cases, we are not going to want to rely on DHCR to make these decisions. And then I think that is the end of the presentation. And Ellie can come back up, and if anybody has questions, we will take them.
It's all right if you
you don't have. Oh, I see one. Yeah.
So, Joanna, this is, it's for you, I think we talked, a bit about, rent reduction orders and how it's not that easy to figure out whether there's a rent reduction order because they're not reflected on that. So what is your advice on how to really subpoenaing the entire HCR record? What's the right thing to do when you have literally no idea whether it is or it's not right?
There are two things you can do without a subpoena. My plug is really to go to DHCR in person. Obviously, it's not necessarily practical for every case, but I really like going to DHCR in person because you can specifically ask them, hey, are there any rent reduction orders? Are there any MCI orders? Is there this? Is there that? And get them to usually the person who works there is very helpful. You have to make an appointment in advance, at least 1 day in advance. They usually have appointments within about a week. And so it certainly is a major time suck, but if there's interns that can do it, or if you can do it, I think it's worth doing it at least some cases. But that being said, if you don't want to go down to DHCR in person, you can do it with a FOIL form. And I believe that the procedure I would use is that there's a form on the FOIL request for sort of a docket list of all cases. And then if that docket list is generated and you see any cases, then you can then submit another FOIL request form for those decisions, which is a very clunky way of doing it and not at all ideal. But it is something that might be, that it shouldn't take that long to do all things considered, because it should be about 10 to 20 days in getting the initial docket, and then another 20 days or so for getting the actual results. And in that time, hopefully judges would understand that you have some pieces in front of you that you need to look into, that if you need an adjournment in your case, it would be worth doing. So yeah. I mean, I do, because you would never think that the case I had involving rent reduction order, I would never have assumed she had an overcharge claim, let alone that, and it really is.
Yeah, I mean, it's very easy on the FOIL form. It's the same, I mean, maybe you do want to go down and look at your client's case, but let's say you don't have the time. The FOIL form, it's just about checking the box. I want to see all the index numbers. And so you should just do that routinely in every single one of your cases. And that's where the MCI orders also come up. And there are other reasons why you might have a docket. And it's just, you should know everything about the apartment that you're litigating about. And so you absolutely in every case should be looking for all the docket numbers associated with that apartment. I see.
Questions. One is with regards to the example of our substantial rehabilitation. Is that only working to be substantial rehabilitation?
No, substantial rehabilitation still exists as a way for a landlord to deregulate the building. And the thing that's tricky about it is that some buildings were substantially rehabilitated without getting an order from HCR. But that doesn't stop a landlord decades later from claiming the building was substantially rehabilitated. And so, but that will, HSDPA didn't touch this. There's some new legislation that for buildings that are substantially rehabilitated, I think after 2023, have to apply for substantial rehabilitation within a 12-month period. But most of the time you're going to encounter buildings that look to you like they should be rent regulated, or even buildings that your client signed rent regulated leases for like 20 years. A new landlord comes in and decides they think they can make out the case for substantial rehabilitation, and they'll pull the rug from beneath your client's feet. Whether or not a building has met, there's a, on the DHCR website, there's a policy memo or a fact sheet. Operational bulletin. There's an operational bulletin that lays out what a landlord would have to do to make out the case for substantial rehabilitation. Is it 75% or 80?
75%.
Yeah. You have to replace 75% of the building systems, and there's some other things in it, and these are, especially when you're dealing with a building that claims a substantial rehabilitation that, let's say, took place in 1980, these are really hard, and we've seen that, these are really hard cases, but you may be dealing with one where it's in, I don't know, 2005, which will probably be easier to figure out whether or not it actually happened.
So with regards to forms for giving if a tenant is not like not in housing for so you might get the registry to discover their was there any recommendations for the process or
I mean, the other form is Supreme Court. A tenant can bring an overcharge case, but it's hard to know which is quicker. I mean, as I said, we're litigating a case right now. We filed in, I want to say February 2018, and you know, if we go to trial, and who knows, it's a while. So I can't.
That's not really typical.
It is, you're right, it's atypical. We did have an appeal in the middle of it, which is probably atypical.
I mean, I would say the Supreme is clearly preferable. And one thing to get discovery is the discovery at HCR. But the thing is, then you have to have the capacity to, the resources to do the case.
Or you need a tenant who has resources and can hire a private attorney. Yeah.
I have a comment and a question. Ed Miller once told me in choosing a forum based on like Supreme Court versus HCR that like you have to think about what HCR is good at, and they're not terrible depending on the facts at like determining if something is rent stabilized or not, but they're probably a lot worse at like overcharge damages. That's my 2 cents. But my question is, how do you think you calculate the rent post Harvey, like in rent settings post Harvey? Even if we can look back, are you saying like, are we going back to the last reliable rent registration, or wouldn't we like always try to use the default formula? Like try to argue fraud to be able to use the default formula?
I mean, I think as Ed mentioned, there are certain cases in which the default formula is not going to be so helpful, right? Like if you're dealing with a building that has been almost completely deregulated, finding a comparable unit and your client moved in at a high rent and they're in a high rent, assuming there is such a thing as a sampling method, if the neighborhood is not going to be helpful to you, you may have an argument that, you want to, I guess it's fill in the gap, right? That you go back to the last reliable and then take all the applicable increases. That you have to do, you have to sort of take into consideration all of those things.
Right. And then the other thing that we didn't talk about, which is a big can of worms, is assuming that you're going back and filling in the gap to get the current rent, but is it collectible or is it frozen because the landlord didn't like it? There's no simple answer to that question at this time. Because what you have is legal changes saying that you don't have a rent freeze unless there's fraud. But other people might say that the genome applies where it's like you change it in one context of the landlord, good faith is supposed to be relied on good faith, smart guidance. And so we apply outside of that, there should be rent freeze. And the courts kind of all over the place about whether there's a freeze the collective. There's very little guidance of what happens because in the land registrations, but honestly, it's never been clear because with the landlord register all the new rents that weren't actually going to change. So how do you ever fit them down? Those used to discuss this. So, but people just know that that's an issue that if you're going back, with Harvey, to give the landlord the benefit of those due increases, but you argue for rent freeze. And I think the answer really is that the rent freeze is a big bargaining chip for most of these cases. Many of these cases settle, and so you don't need to have an airtight, legal argument like you were writing a law review article. You need enough to intimidate the other side so you can get a good deal.
Going back to when requests that cases raised to an apartment that were. I requested one for a building that's very large, so there's a very large number of buildings that cases worth of cases. When I get these, should I request everything? Which are ones that say denied? I'm assuming someone at the HCR will just get everything right for request everything.
Well, I really, again, go back to the point of go down to DCR for that case, because then you can just say which ones of these apply to my apartment, and ask them to print out those ones, and that person can help probably work with you and look through what's actually going to be relevant to your case. That might also be a scenario if you don't for some reason want to do that, where you might want to do a subpoena and specifically seek any orders that are relevant to your apartment number. I don't know.
I don't know, I mean, I'm curious about the fact that there are all these denied ones. Is it a reduction order that they kept trying to lift and weren't able to? I want to know that. Were they constantly being denied MCIs? I kind of want to know that too, because it may go, depending on what you're arguing, if the agency keeps saying you're filing things and we're finding them incorrect, that might go to building your case. So I think you should go down and have a conversation. I think it's worth it.
It is, but I wanted to see an example of what I should be looking for. Even if I'm not looking at this, I want to learn.
Yeah.
Because this one actually had the responses. A lot of the case history that I requested had one or two, and they didn't look relevant. This one actually had something to pop up, but the major fuel cost report, I don't know if that's relevant or not, but I requested.
Yeah, that's going to be relevant for. Is this a convert? Was purchaser converted? Yeah, there could be like rent control tenants who are still left, because that fuel cost has to do with how they calculate the rent control apartments rent, or used to be.
I don't know, there's no list of things that we look for when we get that history down. You kind of have to investigate case by case.
But the other thing is there's a secret prefixes of the DCR proceedings, document scheme. Yes, they used to have that. And I'm not sure.
Some of the agencies have the answer to this. There's an acronym list for HCR that we
The document list also says what type of proceeding, so you can clearly see like if there was a rent reduction order, and then it says like owner application, if you could tell it, it would say if the owner application to restore rent is denied or not. And you can also then look on the DCR case status inquiry online and see if there are any related cases once you know there's a rent reduction order. And if there aren't any, then you know.
Are there cases where courts have done like a bifurcated analysis? Those are about claims that accrue the HCA and post HCA, or like that straddle that? Not yet.
Not yet. And as I alluded to, there's at least one decision in Brooklyn where all the claims accrued post HSTPA, but the tenant who did pre HSTPA, and the judge found Harvey didn't apply. which is really weird. And then, it's Weisberg, right? And, he cites two cases that when you read the cases, they don't really say what he says they say. I think we're asking to re-argue that.
And that's not the final word, just one judge in Brooklyn held it.
No,
Certainly doesn't
but I
mean
guess
that
what
we
I'm saying
should
is,
discourage.
right, no, absolutely, that's a stupid case for everything. But all I'm saying is, it points to some pretzels that judges will tie themselves in pretzels to get around party. And so, like, don't be shocked when you see that. You're gonna see some really dumb decisions coming out of these courts. In the next couple, the next couple months.
So I have another substantial rehab, but, I know landlords don't claim substantial rehab regulation. If goes through all the units, and that, if you have a situation with a fire, for example, in cases where they have to, got the entire building.
Well, even if there was a substantial rehab, any existing rent stabilized tenant retains rent stabilization rights under the. I think that then that would not necessarily matter. It's just because you can have tenancies you can even have a tenant remain in occupancy and the substantial rehabilitation would still occur. It's just that tenant retains the rent stabilization rights.
Right.
And so. Yeah, I think it just turns on a factual question of whether this requisite work was done unless that's wrong.
Another question about burden of proof in these cases. Critical simply, if the landlord feels that the property was deregulated, the tenant would say they will deny. I assume the landlord would have to keep every element of that was properly deregulated, including that the notice is not even served. Or if the landlord says the rent is not something. Well, on a different planet, that would be true. Here in New York City, I think it's weird, that's right, they have to, there are cases that say, so they always have to prove to show, that the apartment was regulated and why, but in practice, I think it's
Right. So yes, but don't expect that to win in front of a judge making that argument. Right, not that you shouldn't try to hold the landlord to their burden, but anyone who's been in housing court understands that housing court is housing. I think we're out of time. Thank you all so much. Feel free to so that you can get your CLEs, and I think there's a beer and wine